My name is Briana Chua, and I'm one of the founding members of Arizona Injury Law Group. I am also a certified specialist in workers' compensation law by the State Bar of Arizona. This video is to help you prepare for a hearing at the Industrial Commission of Arizona. Your initial hearing in an Arizona workers' compensation claim is your only chance to tell the administrative law judge assigned to your case face-to-face what you are seeking and why you should receive it. If you have any non-medical and non-expert witnesses to present, this is also the time that you would want them to attend to provide their testimony. You will not receive an order or a subpoena for your attendance at your hearing. You will only receive a written notice of hearing. You are expected to arrive on time and on the date scheduled for your hearing. Your witnesses will receive a subpoena if you requested them ahead of time and in compliance with the rules of procedure. Time permitting, your attorney will probably want to meet you before the hearing to discuss any last-minute items. This is not the time to ask questions about your claim unless it deals with the issue being decided by the judge. The reason is that you may have limited time. You want to give the attorney time to ask you any last-minute questions or to tell you any last-minute updates about the hearing itself. The hearing rooms at the Industrial Commission of Arizona are not what you see on TV. They are generally smaller rooms with a judge's bench that is elevated, a witness stand beside the bench, and a long table for the attorneys. In the back of the room, there are usually a few chairs for those who are not testifying. Your hearing at the Industrial Commission is not public. Therefore, the only people permitted in the room are the judge, court reporter, attorneys, parties, or their representatives, and witnesses. If there are several witnesses in your case, a party may invoke what we call the rule, which means the judge will order all non-party witnesses who are not testifying at that very time to leave the room and not discuss the matter while outside. The purpose of this is so the other witnesses cannot hear the testimony of others before it is their turn to testify. If you have a spouse or a friend that you want to attend the hearing, you may have him or her sit at the back of the room as long as he or she will not be testifying. If you are the applicant or claimant in the matter, you and your attorney will remain in the hearing room the entire time. Once the hearing begins, the judge will open the record and provide a short recitation of the procedural history and the issue that he or she will be deciding. You will likely be sitting beside your attorney and eventually will be called to the stand to be sworn in. Then your attorney will begin asking you questions. This is called direct examination. It will allow your attorney to guide you through the necessary information that your attorney wants to put on the record for the judge to consider. You should follow your attorney's lead because he or she will know exactly what kind of information needs to be solicited for the judge to make a decision. After your attorney finishes asking you questions, the defense attorney, who represents the employer and the insurance company, will also have a chance to ask you questions. This is called cross-examination. After the defense attorney finishes his or her cross-examination, your attorney will be able to ask additional questions, which we call redirect, allowing you to clarify or elaborate or explain anything that you were unable to do on cross-exam. The length of the hearing will depend on the issues being presented and the parties involved. If there are a lot of witnesses, the hearing will take longer. If you are the only one testifying, then obviously it's shorter. On average, hearings usually last about 30 minutes, but they can be as short as 15 minutes or even as long as several hours. Usually, judges will schedule only 1 to 2 hours per hearing though. And if you need more time, then the judge will often stop the hearing and schedule a further hearing for additional testimony if needed. You should wear clothing that is respectful and appropriate to the setting. That means something conservative, clean, and neat. You do not need to wear a suit or heels. You do need to be comfortable though. If you are a female and you want to wear a skirt, consider the fact that you will be seated slightly elevated and facing the attorneys. There's no privacy panel on the witness stand. Take any assistive devices, casts, boots, etc. into consideration when choosing your footwear and your clothes. Basically, if your outfit would be fine to wear to a religious event or a daytime work event, you should be fine. You may wish to dress in layers though, as the rooms can be hot or cold. The hearing is really for your oral testimony, so you generally do not need to bring anything. However, if you need a cheat sheet with dates or a timeline written down, it's fine to bring that. Just remember that anything you bring and refer to at the hearing may need to be shown to the defense attorney. In other words, those documents you refer to will not be confidential or just for your own reference. If you want to bring any documents with you, you should really show them to your attorney before the hearing and make sure it's okay. Your attorney, on the other hand, will bring his or her entire file, including all your medical records. You may want to bring a sweater in case it's cold, water in a leak-proof container or bottle, tissues, cough drops, things like that. If your hearing is close to the lunch hour, you might also want to bring a granola bar or some cash or change in case you want to visit the vending machines on a break. You may want to take a break during the hearing, especially if it goes long, but you'll need to ask the judge for permission. If you become emotional or just need to go to the bathroom, feel free to let the judge know. You'll need to answer the question that's pending before the break is granted, however. The judge is considering and weighing all the evidence and arguments. This includes not just documents and the substance of what you and your other witnesses say, but also your credibility. This includes, but is not limited to, the way you come across, your eye contact, charisma, tone of voice, things like that. In most circumstances, Arizona workers' compensation claims have more than one hearing before a judge will be able to issue a written decision. The judges do not tell you their decision at the hearing. They issue a written decision after all the evidence has been submitted. Before making a decision, the judges will need to have all the information, including your testimony, as well as the testimony from any witnesses and expert witnesses, doctors, etc., that can provide evidence relevant to your claim. Therefore, at a minimum, you can usually expect to have at least 3 hearings total before a written decision is issued. Those hearings would be for you, your doctor, and the defendant's doctor. Once all of the hearings are completed, the judge will state that the matter has been submitted and issue a written ruling, which will be mailed to either you or your attorney. If you are represented by an attorney, the administrative law judge will usually excuse you from attending further hearings for the doctors and expert witnesses. Your attorney will attend those hearings on your behalf as your representative. Ultimately, however, you need to follow the direction of your attorney as to whether he or she wants you to attend the further hearings.